Yes, nobody is interested from the respondent side.
Respondent had filed reply, I have entered appearance on behalf of respondent number 1 yesterday still. Well, briefly, I will, if I may submit, my lord.
Yes, submit.
My lord, on the last date of hearing on 5th of March 2024, this matter got listed after 10th of July 2021. It was listed in the Lok Adalat. And before that order sheet of 2019, my lord, 27th of August 2019. If I may read the order. 27th of August 2019.
Yes.
Let the matter be listed in the next week to enable the counsel for petitioner to argue the case on the question of limitation as he is seeking compliance of order dated 16/5/2012. Now what has happened, my lord? The respondent number 4, the then executive engineer, had filed a reply stating that the order was passed way back in the year 2012. Now when this, if I may read R1 of the reply filed on 4th of April 2019.
No, you want to raise plea of limitation?
No, not limitation. We have filed an application for extension of time. The present executive engineer respondent number 4 has filed an application yesterday itself. It might not be in the file. We have filed it yesterday only.
For what?
For an extension of time on the reason that when this matter got listed on 5th of March 2024, he came
March?
5th of March 2020, the last
Yes,
order, my
Lord,
lords.
yes.
Order. Well, my lords, findings were that the order passed in compliance of the order passed by learned this High Court is prima facie found to be false. The last paragraph of my lord's order
What is wrong? What is wrong with that order?
No, there's nothing wrong with that order, my lords.
So
What has happened on 5th of March, this order was passed. On 8th of March, the present executive engineer got knowledge of this order and he
why they were supposed to be remain intact with the court procedure?
No, my lord. That's not the case here. When the reply was filed way back in 2019, the very same executive engineer got retired in 2019.
What was that reply?
That is my lord, respondent number.
That reply was intended to deceive the court. That's why I have observed that reply filed by respondent number 4 is deceptive.
Yes, my lord. I bow down to my lord's observation.
And I called upon him to give comment. What is his comment now?
No, the one who has filed the reply is no more in service now. He has superannuated in the way back in the year 2019. Now, what has happened? After my lords passed this order, he came to know about this order on 8th of March.
Why he came to know thereafter?
Because
why not on that when case was listed? They have no track of the cases?
No, the present executive engineer is not party to the contempt petition. That's the case. And we have stated on affidavit that we'll comply with the order in 4 weeks. That is the reason he has
4 weeks.
No, he has
Contempt is 2018. Order was 2012. And he needs 4 weeks or?
The reason being is, my lord, if this
right reason I know. Now reason I will show in my order also. What type of attitude is being adopted by these officers?
My lord, what I humbly submit, my lords.
Anything else, sir? I am not agreeing with you.
The reason being, my lords, the matter was listed on the last week on 5th of March. What has happened? The reply was of 2019. Thereafter, matter did not got listed. The matter got listed in Lok Adalat. There was the direction to be listed before the regular bench.
Yes.
Now
it was listed.
It was listed, my lords.
Name of the lawyer appeared in the cause list.
No. Well, I was not appearing on respondent number. He was.
Yes, respondent counsel appeared.
On behalf of the then executive engineer. Now
on 5th March 2024, lawyer appeared on behalf of all the respondents.
Ma'am, my lord, lawyer appeared on respondent. He had filed power on behalf of respondent number 2 and 4.
Presence is on behalf of respondents.
I have no knowledge about it. The present executive engineer approached us.
It is his problem, sir. It is his problem. They have not maintained the list of those cases pending in the High Court, including contempt, because they don't bother. As simple as that. They are not concerned with the contempt. They know nothing can be done by the court.
No, no, my lord.
There, this misconception I want to remove.
No, no, my lord, that's not the case. I bow down to my lord's observation, but that's not the case. I have filed a letter.
Then let us have his explanation now.
My lord,
In pursuance of the last order.
my lord, I have filed a letter. He directly communicated to the topmost authority. That
Now he will do everything. I know. He will do everything. He will not leave any such stone on his way. He will tell everything. But he will not comply with the order.
No, no, we are bound to comply with the order passed by this honorable court.
Order was passed in 2012. Till date not complied with. Contempt was filed in 2018. Is it not a mockery of the system?
My lords would kindly appreciate the fact that the very order was passed in 2012. If his
Very
objection
order,
was,
this order, that order, listed in Lok Adalat, this and that, but fact remains, order has not been complied with.
my lords,
And order has not, order of 2012, not complied with even after 12 years.
as a matter of last indulgence,
And the officer is having this face to say that earlier incumbent has retired and he will not implement it.
no, no, my lords, we bow down to
What is his explanation?
my lords. He stated, my lords, in the paragraph number 5, my lord, he states that, may I read, my lord? The answering respondent respectfully submit that the answering respondent had no knowledge about the pendency of the instant contempt petition. The answering respondent came to know about the instant contempt petition only on 8/3/24. As soon as he came to know about this instant contempt petition, he immediately communicated to the highest authorities seeking instructions in the matter. Copy of the communication is AR1. Then it will, my lord, paragraph number 6 says, it will thus be seen that there is no willful deliberate disobedience of the order passed by this honorable court on the part of the answering respondent. As what I humbly submit. Not 4 weeks.
Chadar Jadgali.
No, no, my lords.
And he will sit home.
We are bound to comply with the order, my lords.
Sit even anywhere.
My lord, we are bound to comply. My lord, may give
Comply,
us
then
2 weeks, my lords.
Comply.
2 weeks.
Who is stopping you?
We'll do it, my lords. Not 4 weeks, 2 weeks, my lords. My lords may have it in the first week.
You should have complied with by now. In view of last order passed by me on 5th.
My lord, the executive engineer cannot pass it. The engineer in chief or the chief engineer will have to.
Let engineering chief make him to go somewhere else.
No, no, my lord. We will do it, my lord. My lord may grant us 2 weeks.
This is only a hierarchical problem with the officer. At the most, they can take shelter of it. I am not the competent authority. I have written to chief engineering chief. Engineering chief will say, I am not the contender. Let this officer go inside.
Although all of them are the party, my lord. They are bound to, my lord.
Anything else, sir?
My lord, 10 days time. We'll do it, my lord.
Anything else?
My lord, I bow down to my lord's observation, but my lord, as a matter of last indulgence, my lord.
Very serious issue.
I can only bow down to my lord's observation. Can my lords may grant 10 days time? We'll do it, my lord.
Affidavit has been filed by Shri Akash Miglani. No. Who has filed this affidavit?
My lord, it's on behalf of the respondent number 4, executive engineer.
क्या नाम है? नाम भी होगा कोई इसका?
शुभम अग्रवाल.
Affidavit has been filed by Shri Shubham
Shubham
Agarwal, executive engineer.
WRD, my lord, it mistakenly written PWD. WRD, Water Resources Department.
Executive engineer.
Water Resources Department.
यहाँ PWD दमो लिखा है.
हाँ नहीं, WRD दमो.
Executive engineer PWD दमो. In compliance of the order dated 5/3/2024. This court is not convinced with the stand taken by The respondent number 4. The original reply earlier filed on behalf of respondent number 4 would show that the representation of the petitioner was statedly decided on 8/8/2012 by the Chief Engineer, Water Resources Department, Sagar. Full stop. Evidently, the aforesaid order was not passed on the representation of the petitioner, which was filed on 15th September 2017. As per order dated 16/5/2012, passed in WP number 3832 of 2006, the case of the petitioner was to be considered for regularization after his reinstatement in the light of existing policy. Full stop. An appropriate decision was to be taken by the competent authority within a period of 4 months from 16/5/2012 by ignoring the report of scrutiny committee. However, the said order was rectified on 13/6/2017 only to the extent of mentioning the date 1/9/1998 in place of 9/9/1998, 1998 in place of 9/9/1988. First up, even thereafter, the case of the petitioner was recommended on 22nd July 2021 by the Superintending Engineer, Water Resources Department, Sagar Division, Sagar, and the Executive Engineer was directed to revisit the case of the petitioner in the light of orders dated 16/5/2012 and 13/6/2017. The reply filed by the respondent number 4 was prima facie found to be farce by this court in the order dated 5/3/2024. Today, Land Counsel for respondent number 4 submits that the earlier incumbent has already retired and the present incumbent has taken over very recently and ultimately came to know about the order dated 5/3/2024 only on 8/3/2024. It is highly imaginary that the department has not kept the inventory of cases which are pending in the High Court, including the contempt petition, where the earlier incumbent has already taken a particular stand. In view of above, this court is of prima facie view that the respondent number 4 has committed. Yes, Mr. No, please.
Not we.
No, please.
We.
This story has to end somewhere.
It will end.
Not in one case.
We assure you.
This is in every case. This is the. Let me pass some drastic order.
maybe most humbly pray, Lord. This
Sir,
is
this is not a single case, sir. You please keep on sitting here. You will find 15 of cases today of similar nature.
no, Lord,
2012 order not being complied with.
Lord, we have
Contempt is
Lord,
2018.
it is an old modern, Lord. If I may most
Sir,
respectfully
where that
say-
fellow will go,
No, no, Lord, they
that
also-
fellow may die even
they,
without
the petition.
any fruit of the order.
No, no, your lordship is very correct. Lord, the petition was also
Mr.
not
Rupra,
listed, my Lord.
there has
That's
to be
why-
some end somewhere.
Lord, this
Yesterday also, I held one officer guilty.
Yes,
Two of the officers, I have already held them guilty.
yes.
And orders are to be passed on the next date of hearing. If my orders are not challenged,
No, no.
I will ensure that contempt petitions are not to be taken lightly by the
No,
department.
absolutely. We're not
Very
taking it
strange.
lightly, Lord.
Contempt has become execution here
No, Lord, it will be. It will
because there is no conviction recorded by the court so far. So they will treat this
No, no, Lord.
contempt to be
This-
executing court.
No, Lord, in this particular case, what happened, Lord, the petition was not also listed for such a long time, Lord, and it's a very old matter, could not be taken up, Lord.
You have no inventory of the cases.
No,
He
we-
says, I came to know about this case only on 8th.
Lord,
Very funny.
that is a mistake, Lord. I go down to.
There is no inventory prepared by the department that
Lord,
so many cases are going on in the High Court,
No, no, they have,
including contempt.
Lord, accidentally, Lord, this matter would have been left out, Lord. But I assure
No,
you,
it is
Lord,
not accidentally,
that
sir.
this will be complied with, Lord. Lord, we've just filed our wakalatnama on behalf of the.
It will be complied with. The moment this fellow go inside, it will be complied with. That I know how to get it complied with now.
Lord, may I pray that the Lordship may kindly take it.
Courts are not helpless.
No, Lord, absolutely not. Lord, I assure your Lordship, Lord, it will be complied with.
This is journal perception. The courts are helpless.
No,
Our lawyer will plead no instructions. Court will adjourn the case.
no.
This is the perception, journal perception, which has been perceived.
They know the Lordship's court also very well, Lord, and none of the contemners will be spared.
I can't tolerate such type of nuisance.
Lord, your Lordship is absolutely right, Lord. May I just pray, Lord, in this particular case, we'll comply within 2 weeks. We have already, the person came only yesterday, Lord.
From FSI view that the stand taken by respondent number 4 is not worth acceptance, but still a week's time is granted to the Learned Counsel for the respondent number 4 to make sure that the order is fully complied with by the next date of hearing, failing which it shall be presumed that the respondent number 4 failing which an appropriate order shall be passed.
We'll do that,
Mr. Rupra,
Lord.
with heavy heart, I am not inclined to spare such
Yes.
type of incorrigible
Yes,
conduct of an officer.
yes, we'll go down to that.
2012 writ petition direction, even after 12 years, no compliance, very strange.
It will be done. So great.
Next week, at the
Yes.
top of the list,
Great.
particular date.